Good morning, my name is Marco Rios.
Good morning, my name is Magda Mendes.
And we are Unit 4 with our sponsor, Ms. DeYarza.
Thank you.
Great.
We really appreciate you bringing this to the So your question?
Let me ask you, please speak up. The people in the back need to hear what you have to say too, and we do too, so thank you.
So the question for today is question 3. Is the power of judicial review that allows courts to overrule state laws and laws made by Congress consistent with democratic principles and ideas? Why or why not? How did Chief Justice John Marshall justify the use of judicial review? In what ways do justices of the U.S. Supreme Court determine the meaning of the Constitution? What are the checks, if any, on the U.S. Supreme Court? Please begin.
Scarcely any political question that arises in the United States that is not resolved sooner or later will become a judicial one, observed Alex de Tocqueville in his classic 1835 study of early American life. Essentially, it has shown that the Supreme Court has judged federal law and protected the Constitution. This principle first originated when Duke of Normandy introduced these ideas when he conquered England in 1066. Here they established a mixed branch which served legislative and judicial functions, which was then recognized as curia regis. However, the courts then noticed that it would be more efficient to judge by precedent.
Influenced by the aforementioned English legislation, 7 of the 13 American colonies adopted some form of judicial review into their own state constitution. This concept eventually influenced Alexander Hamilton in Federalist Paper No. 78, where he predicted the existence of judicial review, ultimately paving the way for the inclusion of judicial review in Article 3, Section 2 of the United States Constitution.
As Marshall pontificated, it is emphatically the province and duty of the judicial department to say what the law is. The judiciary performs its role in 3 main ways. First, its interpretive decisions can uphold the legislative powers of Congress. Second, it can check by overreaching Congress through its implied power of judicial review. And third, the Supreme Court can also act as a catalyst on the House of Representatives and on the Senate when it's not able to make decisions. However, this power was never explicitly mentioned in the original text of the Constitution, but it was established in 1803 by the Marbury Doctrine, when Justice Marshall determined that although Madison's refusal to deliver the commission was unlawful, the court could not issue a writ of mandamus since Section 13 of the Judiciary Act of 1789 was in direct contradiction with the Constitution.
In addition, judicial review plays an essential role in being the fundamental check of the Supreme Court on the other branches of government, such as in Clinton versus Jones, in which the Supreme Court held that Clinton was subject to the law.
When creating the United States Constitution, our framers created it based on some fundamental principles of American democracy, such as individual rights. Judicial review has guarded citizens' unalienable rights, thereby expressing democratic ideals. For instance, in Engel versus Vitali in 1962, the Supreme Court was able to protect us from the establishment of religion by upholding that the law was in violation of the First Amendment. While judicial review constitutes an essential feature of the American political system, unrestrained judicial review sets a dangerous deviation from democratic principles due to the fact that judiciary does not have complete independence and there are limitations that are supposed to be placed on the judicial branch.
For example, Congress may propose amendments to correct judicial decisions, such as in Barron v. Baltimore, which was then overturned by the ratification of the 14th Amendment, which enabled the incorporation of the Bill of Rights so that they could also be applicable to the states. Furthermore, there are several approaches that Supreme Court justices can interpret the United States Constitution. However, justices are prone to 2 forms of interpretations, either judicial activism or judicial restraint.
When judges use a more originalist form of interpretation, they base their decisions on the original understanding of what framers intended the Constitution to be, and also use legal precedents. For example, in Debs versus United States, the constitutional issue was whether Debs' conviction for criticizing the law was in violation of his First Amendment. The court used the decision, as in Schenck versus United States, as a precedent and was used to limit the First Amendment. On the contrary, when justices use an activist form of interpretation, they tend to go a broad interpretation of the Constitution. An example of this can be Obergefell versus Hodges, where the court ruled in 2015 that the right to marry is guaranteed to same-gender couples by the 14th Amendment. However, the 14th Amendment original intent was to grant citizenship, but they used this to have equal rights.
Throughout the course of American history, every branch of federal government has taken seriously the sworn duty of the upholdment of the United States Constitution. However, the Supreme Court has the official role in defining the United States Constitution. In the words of the former Justice Charles Evan Hughes, "We are under a constitution, but the constitution is what the judges say it is." Thank you. Thank you.
You reference the article of the Constitution referring to the Supreme Court, which indicates that the Supreme Court justices are appointed for life. Should there be term limits on the justices of the U.S. Supreme Court? Why or why not?
Article 3 basically defines that the judiciary is independent from the other two branches. This makes sure, as argued by Federalist Paper number 78, that the judiciary branch is looking at the constitutionality of the actions and that they don't look at contemporary ideas as much as they should look at the Constitution.
Additionally, I believe that Supreme Court justices should be elected for lifelong tenure because the public doesn't have any say in the decisions that the judicial branch makes. Therefore, we shouldn't elect our judges, and that should be the Supreme Court has no political affiliation. Therefore, Supreme Court justices should be held for lifelong tenure.
Contrary to what my partner has said, Marco, he in Anti-Federalist Paper, British 15, he argues that the judiciary would be too independent if it would last. They would have life tenure, so it would be better if they would have term limits, such as the president, and it would make the branches more co-equal.
And in the words of Oral Warren, the sword of censorship pierces through the First Amendment. Essentially, this has shown that sometimes the judiciary branch has looked at the First Amendment and needs to protect it. And this can be an example where the Supreme Court has protected an amendment rather than looking at contemporary ideas. An example of this can be in Tinker v. Des Moines, where they ruled that students could use their freedom of expression to wear armbands into schools and that this isn't unconstitutional. And this essentially shows that people have the right to all the amendments listed, and essentially the Supreme Court needs to protect it, and despite these contemporary ideas, they need to be protected.
If I can follow up on my colleague's question, you indicated that judges are independent, yet we know that Democratic presidents nominate about 95% of the people they nominate are Democrats, the same for Republicans. So is the Supreme Court and the federal court system truly independent in the sense of independent from partisan politics?
Well, judicial review is what truly makes the judicial branch a co-equal branch of government, with the other two branches checking the actions of the executive as well as checking the actions of the legislative. An example of this can be in Clinton versus Jones, where the court ruled that Clinton was subject to the law, and in addition to that, an example of this can be in Nixon versus U.S., where the court held that Nixon was subject to the law and what he was doing was unconstitutional. So this can be an instance when, even though the president-elect appoints the Supreme Court justices, the Supreme Court still has to follow the procedure, and they have to check if the executive branch is doing an abuse of power.
In addition to what my partner has said, another example where judicial review was used to uphold checks and balances, to check off the executive, for example, in Little versus Barem in 1904. Here, the constitutional issue was whether a president order, which in effect attempts to make law, can override an act of Congress. Here, the decision was that no, they cannot, because the legislature's power is to create the law while the executive is to enforce the law. And although the executive also, how my partner has said, appoints justices, the judiciary's job is to uphold the Constitution.
However, I disagree with Nico and Maite due to the fact that complete independence from partisanship isn't guaranteed. And even if we look at Marbury versus Madison, in other cases, we can see that they haven't taken the idea of judicial review and Hilton versus U.S., but the idea of the Federalists essentially wanted to expand the federal government's power and wanted judicial review, therefore had that decision. Essentially, we can also look at the Earl Warren Court and how they expanded the judiciary's power in Baker versus Carr, where they assumed a legislative power and essentially had judicial activism. And this shows that sometimes, despite it being void from partisanship, there isn't a complete guarantee that it will be completely void. And in cases such as Roe v. Wade, despite it being a very controversial topic, they use judicial activism in somewhat somewhat to promote these ideas that abortion is guaranteed under the 14th Amendment.
Can I ask a question about judicial activism and judicial restraint, which you
Yes.
mentioned in your opening statement? Which form of judicial perspective do you think is most beneficial for democratic polity?
Judicial restraint and judicial activism are both judicial interpretations that the judicial department makes when interpreting the Constitution. They are both very essential for our government. And judicial restraint, it mostly focuses on looking at the original intent that our framers wanted our Constitution to be. Although they may have some flaws or disadvantages, I believe that judicial activism is more beneficial or a better way to interpret the Constitution, because, for example, in cases such as in Roe versus Wade, they were able to adapt the Constitution and make it more flexible to modern times by giving privacy rights to women by the 14th Amendment.
I, however, disagree with my fellow colleague. If you look at judicial restraint, specifically the originalist form of interpretation, we can see how they applied the 14th Amendment to the states through the slaughterhouse cases, looking at the original intent of John Bingham, the writer of the 14th Amendment. Essentially, judicial restraint shows what they intended.
Thank you
All
very
right,
much.
thank you.
Now we'd like to give you some feedback on what was, I think, is a truly excellent performance that you gave. You had strong knowledge of kind of the theoretical and philosophical background of the topic and the question. You did a great job of bringing in the constitutional issues. I love the way you brought in the Federalist Papers, constitutional cases. You had an awareness about what the Supreme Court did over the course of its very long history by bringing in different cases and different perspectives of the court over time. You cited specific articles of the Constitution where different judicial principles were vested. I thought you did a wonderful job when you addressed the questions, particularly in terms of everyone on the panel taking a part in answering the questions, giving very strong, very deep answers, and also when you disagreed, it was extremely respectful, and it played off of the answers that had been given prior to that. I just felt you did a wonderful job.
Yeah, I agree. I thought you did a very good job. The hallmark for me of a good hearing is I wish we'd have more time to keep talking, because I think you had a good level of knowledge, and I wish I could have explored some more ideas with you, particularly in response to the question my colleague asked about activism and restraint. It's the kind of thing that we hear tossed around in discussion all the time, very little understanding, and I think we could have learned something that refined. I like the use of Marbury as evidence of a lack of independence from partisanship, because that's exactly, it's not accidental, and the way that the decision is crafted. Make sure, and this is something that I think you could use tomorrow and perhaps the next day if you keep going here, make sure that you answer the question that's asked. And at times it seemed to me you were so anxious to show us everything you knew that I'm going to tell you this regardless of whether it answers the question or not. You eventually got to the answer, but what that did was prevent us from delving more deeply into some of the stuff that you did, and so you should do that. But I thought an excellent job.
It's always difficult being the third person to give the feedback because you almost want to say ditto. Okay. But I want to pick up on something that Joe said. You've obviously studied the question very well. You know a lot about it. But when you're answering the questions, be selective. Tell them just the essence of what you want to hear, not necessarily everything, because you lose it then what is the essential point that you want to make or that you're attempting to make to convince somebody. Remember this, for all of your life, you're going to be in the position of selling. They're going to be selling ideas, selling things, and you've got to be very specific on the information that you're imparting to people. so that they're understanding what it is you're trying to sell. You've done a great job of learning the parts of the Constitution. I hope that you will continue to study the Constitution. And when you go on to high school, that you will continue in the We the People program and further develop. Thank you so much for your preparation.
Thank you.
Well, thank you.
Yeah,
You did
yeah.
a great job.
Thank you. Thank you.